Cheers.
Thank you, Mr. Chair. Good afternoon. It is a privilege to appear today on behalf of Christian Legal Fellowship. Thank you for the opportunity to share our perspectives on Bill C-9. CLF is a national association of over 750 legal professionals working with faith communities and other groups across Canada. CLF is also an NGO with special consultative status with the United Nations and has intervened as a friend of the court in over 40 cases involving the Canadian Charter of Rights and Freedoms, including in Whatcott, where the Supreme Court cited CLF submissions in its unanimous decision. Let me start by affirming that CLF shares the government's desire to combat all acts that propagate and normalize hatred. And so we wish to ensure that initiatives like Bill C-9 are both effective and constitutionally sound, and that requires a carefully tailored approach in defining exactly what is being criminalized and in what circumstances. The criminal code is, as you know, contains the most severe penalties in our legal system. So the stakes are high in finding the right balance. It means the difference between someone's liberty or incarceration. So in this context, when it comes to defining hateful expression, we need to ask some hard questions. When should someone be imprisoned, separated from their families, from society, branded a criminal because of the words they speak or the views they express? What might we deprive our communities of? Whose voices might be silenced if we don't strike the right balance? What legitimate ideas might never be heard if people are afraid to speak up for fear of being prosecuted as hateful when they aren't hateful at all? At the same time, how do we deal with the concerns that we've just heard about with the growing animus in our country, particularly that which is directed towards minority religious groups? How do we deal with the very real harms that flow from that animus? These are important questions that this committee is wrestling with, that this bill is wrestling with, that we all are wrestling with. And it's important, it's absolutely crucial that we get this right. It is often said that the law is a teacher, and people will learn and look to laws like this one, especially when it comes to our public discourse. In fact, the Supreme Court recently recognized that allegations of hatred are often used in public discourse and used in ways that well exceed their narrow meaning within the legal system. So when it comes to the criminal law, we have to have a clear understanding of what we mean by hatred and why it is a legitimate subject for criminal intervention. Hatred of people is evil, and public manifestations of that evil are appropriately addressed through the criminal law. Other aspects of hatred ought to be addressed through different avenues, such as educational, mental, spiritual, and community supports. Criminal intervention is justified only when someone takes action, what the Supreme Court has called extreme manifestations of hatred. And it is important that we always recognize why that is. It's not because we find certain views offensive, as repugnant as we might find them. It's not because we object to what people think or feel. It's the mode and effect of expression, not the expression itself or the content of the expression itself, that the law must target. The Supreme Court has been very clear on that point. And so the criminal law is concerned when someone takes action to mobilize others to deny a group's intrinsic dignity, to treat them as lesser beings, to take actions which effectively dehumanize others, actions which are ultimately a rejection of a basic compact of our community life together. That is what should be targeted. Expressions that fall short of that threshold, offensive as they might be, should not be criminalized. And so while there's a legitimate role for the criminal law in combating hatred, the law must be carefully tailored to those goals. And we've identified three primary concerns with Bill C-9 in this regard. I'll just quickly summarize them in conclusion. First is the definition of hatred. The term hatred in any context is highly susceptible to subjective interpretation and must be defined more precisely than it is currently in the bill. Second, the proposed new motive offense requires clarification for a number of reasons, which we can get into. We suggest in our written brief that this offense should focus not on an accused's internal emotional motivations, but on whether an accused commits an offense with the intent to incite hatred. And again, how we define hatred is a crucial issue here. And finally, there should be explicit recognition of the freedom to discuss and criticize beliefs, opinions, or practices in good faith. And this clearly would communicate that disagreement is not detestation. That is also consistent with the defenses contained in Section 319.3, which should be also retained to help ensure that the legislation complies with the Charter. A clear line must be drawn between expression that seeks to vilify groups on the one hand and expression which simply seeks to challenge ideas on the other. And substantive amendments are needed in Bill C-9 to help achieve that demarcation and strengthen the government's efforts to combat hatred in line with the Charter. Thank you very much.
Thank you, Mr. Ross. Over to you,